The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. There are 3 cases scheduled to be submitted this morning. Those cases are Iowa Individual Health Benefit Reassurance Association versus State University of Iowa, Iowa State University of Science and Technology, and University of Northern Iowa. Second case is Gerald P. Young, Michael L. Haith, and Susan M. Runyon, individually and on behalf of others, versus Healthport Technologies. And the final case is State of Iowa versus Alvarado. That last case is submitted without argument, and we'll now hear the arguments in Iowa Individual Health Benefit. Mr. Lederer.
Good morning. The issue in this first case for the court is whether or not a not-for-profit corporation established, created by the legislature, and mandated by the legislature to provide an allocation of loss created by selling health insurance on a below-cost basis has the right to sue a member of the entity, the non-for-profit corporation, who refuses to pay its allocated share. There are 2 entities here, and they have really long names. So I'm going to use shorthand for them in order to save about 7 minutes. 513C.10, I'm going to call that the individual. 514E, I'm going to call the comprehensive. Just one name out of their entire name. A little background for the court. The legislature used 514E to create a nonprofit corporation with the established task of actually offering and selling health insurance to people who fell below the market. That didn't work because people didn't really trust an insurance company they hadn't heard of. So in 1995-97, the legislature created the individual as basically a replacement for comprehensive. Individual was specifically a non-profit corporation, and it was charged with the task of requiring all members, and the members are defined, to participate in the providing of health insurance at a below-cost rate to people who fell through the cracks, a very laudatory goal. The problem with requiring the health insurance companies who write in the state of Iowa to provide this coverage means that those companies are going to suffer a policy loss over time given the amount of claims they pay versus the premiums that they earn. And the legislature said that we're going to allocate that loss across all of the members of the entity. And the legislature created classifications of members. And one of the members is an entity that provides health benefits that are subject to state regulation. That, in other words, is someone who's self-insured. For years, you and I in Iowa State were members, paying members of individual, without question. The state of Iowa is a member of individual, a paying member. Now, for years, the University of Iowa was not a member because it was like my law firm. It had a contract with a health insurance company. But starting in 2010, it became, in a sense, self-insured and provided health insurance benefits directly without an insurance company. That meant they became a member of individual. and they received the annual audit request from the association. They filled it out, they returned it, and then after the association allocated all of the monies, they got a bill, and they refused to pay it. And that's led to this lawsuit and the motion to dismiss, saying that individual does not have the power to sue.
Is this issue or this fight something that ought to be arbitrated instead of decided by the judicial branch?
Well, that's the second issue raised here. And that's the issue that the Attorney General has urged. And I can respond to that. 679A.19 provides that disputes between governmental agencies shall be submitted to arbitration rather than litigation. And it defines the people that are agencies: administrative departments of the state government, commissions of the state government, and boards of the state government.
And is your client any of those?
It is not.
What about the universities?
It is most clearly not.
What about the universities?
Well, the universities are probably agencies of state government, sure. But the question is whether there's a dispute here between two state agencies or between one state agency on one side and three on the other.
If we agree with you on that issue and you persuade us on the main issue, and I'm sorry to interrupt you on the merits of the capacity to sue, should we go ahead and decide the arbitration issue or remand it to the trial court, which didn't reach it?
Good question. Had not thought of that. I think it's pretty obvious that the record permits this court to decide that this is not a dispute between two state agencies. The statute, 679A.19, does not refer in any way, shape, or form to nonprofit corporations. The legislature chose, for its own reasons, to make individual a nonprofit corporation. Its board is composed, for the most part, of private citizens. The 12 voting members of that board, 11 of them are private citizens, and 5 of them are representatives of insurance companies. 2 of them are other miscellaneous members of individual. If the legislature wanted this entity to be a state administrative department or a commission or a board of the state government, it knows how to do that. It's easy to say that, and they chose not to. And I think it would be a reach to somehow make it one of those entities under 679 in order to push this to arbitration. And the other thing I have to say about that is we're talking about an interesting issue here with respect to how to allocate these insurance funds. It's the job of the judicial department to decide those issues. This is not a dispute between two governmental entities. It's really not. The board members for individual and for comprehensive, they are not reimbursed for their expenses by the state of Iowa. It says right in the statute, 514E, provides that they shall be reimbursed by the funds collected by the entity, not by the state. There's just, respectfully, there's no way to make this entity a state entity for purposes of 679A.19.
Mr. Lederer, could I take you back to your first issue? The Court of Appeals and the universities make a big deal about this 2001 legislation.
And they should.
Reading the bill explanation, it sounds like the purpose of the legislation was to merge the boards of directors of individual and comprehensive. However, the legislature also went on and struck that sue or be sued language. What were they doing? Why were they doing that?
Wasn't there, don't know. But I would argue that when the legislature created individual in the first place, the language that said it has the right to sue or be sued was superfluous. They didn't need to say that because they already said that it was a nonprofit corporation that had the powers and duties that were created under what was then 504A, which of course has since then become 504. When they made the change in 2001 to basically collapse individuals' board of directors into comprehensive board of directors for, I assume, savings, they also deleted the language about its express powers, all of which are in 504. There's a big difference between removing superfluous language and saying you used to be able to sue and now we say you don't have the right to sue. So what you have now is a statute that creates a nonprofit corporation that expressly has all the powers given to it by 504. And there is no language in either 513C10 or 514E that says that individual does not have the right to sue.
What do you make of the language, though, in 514E2 that says, the association shall also be responsible for administering the Iowa Individual Health Benefit Reinsurance Association pursuant to all terms and conditions of 513? And wasn't that added when they got rid of the sue language?
They did, and that language, because it refers to comprehensive and not the board, that language is problematic. But here's what it doesn't say. It doesn't say that in the future, anything that individual has to do shall be done in the name of comprehensive. If you look at 513C.
I understand, but what does administering mean? I mean, how broad is administering? That's the issue for me, I guess.
I think I would say that it means that comprehensive will do individual's job, and comprehensive board will be the board that rules individual. But if
they do their job, isn't one of their jobs suing?
Pardon me?
Isn't one of their jobs suing if they do their job?
Yes, but the question is who is the suing name? And if you look at 513C10, specifically subsection 6, you will see constant references to the word association. And clearly, that refers to individual, not comprehensive. It is individual who is to send out the audit requests. It is individual which is to do the math that is required to allocate the loss among all members. It is individual who then has to send out the bill, and it is individual who is required to collect the money. And if comprehensive's statutory obligation is to administer 513C10, then if it's time to sue somebody, the entity that should sue is individual.
Can you even, I mean, I served for a while on both a nonprofit entity and then a subsidiary of the nonprofit entity, and there was no question that the first entity kind of controlled the second, but they each had their own individual boards. I was on both boards of directors. I mean, is it possible for one nonprofit corporation to administer another other than through a common board of directors? Isn't this just maybe a clumsy shorthand for saying there's going to be one board of directors?
When you legislate, stuff happens, and that judiciary's task today is to try to figure out what that language that Justice Wiggins has pointed out means to that overall statutory system. But regardless of what administer means, at the end of the day, when you have 3 members who are just flat refusing to pay, someone has to sue. And if you look at 513C10 and you look at 514E, it is absolutely clear that the name of the entity that is in charge of this process is individual. It's not comprehensive. You look through 513C10, its entire text, there is one reference and one reference only to 514E, and it's the reference to 514E's board, not 514E itself, not the comprehensive itself. The only question here is not whether somebody can sue, because clearly the legislature never would have intended to permit members of individual to decide on their own whether they want to play. If that's true, if there is no right to sue, this system, which is providing insurance for people who cannot afford it because they have fallen through the cracks with respect to pre-existing conditions such that they can't buy at market, this system will fall apart because no member is going to voluntarily pay this money. They have to be compelled. They have to see it as an obligation rather than a donation. So someone has to sue. And you cannot logically look at these 2 statutory provisions and conclude that it's comprehensive who should file the lawsuit in its own name. It's clearly individual that is in charge of this process from the statute. Now, what I said in the application for further review is, if somehow the court disagrees and says, no, it should be comprehensive, well, then the remedy under the rules of civil procedure is to remand to permit substitution of the real party in interest. And so if the court disagrees with me, I would ask the court to make that change on remand. Thank you.
Thank you as well, Mr. Lederer. Ms. Stahle.
Thank you. If it may please the court. This case comes before the court today on a motion to dismiss, and it was strictly on a capacity to sue issue. Mr. Lederer has taken the position that the 3 state universities are actually members of the Reinsurance Association. They deny that, and I just wanted to state that at the beginning because this is a motion to dismiss. We had to accept the facts in the petition as pled, but that issue of whether they are actually a member has not actually been litigated yet. The Reinsurance Association, established in 513C, was created by the legislature in 1995. Its task was to assist in carrying out a defined public purpose that was identified in the code section, and that was to ensure the availability and regulation of individual health insurance plans offered by private insurers in the state. Because the Reinsurance Association is a body created by the legislature to perform a public purpose, it only has the authority that it has been specifically granted by the legislature. And what the legislature giveth, the legislature can taketh away, and that's
well, but it was organized as a nonprofit, right?
Correct.
And generally speaking, nonprofits have the ability to sue and be sued. So, I mean, the meat of the issue, for me at least, seems to be this later legislative issue that the Court of Appeals relied on. On the one hand, as I say, the general rule for nonprofits is you can sue and be sued. On the other hand, the legislature then took action to strike the language, if you will. But why isn't that just cleaning up the code? I mean, that's what Mr. Lederer would suggest. Well, it was redundant. All nonprofits have the right to sue. breathe some life into that legislative action
Okay.
that occurred.
Well, first of all, let me start out with the Nonprofit Corporation Act, because you're absolutely correct. As a general rule, all nonprofits have a right to sue. But there's some pretty clear language in there that says if you, nonprofit corporation, are subject to regulation by another statute, the terms and conditions of that statute control. So our position would be that 513 clearly defines what the scope of authority is, and that's what you look at, and that's only what
But
you
it
look
doesn't. Right now, it's silent and I want to hear your answer to Justice Apple, the rest of his question. But as far as this sort of alleged conflict, which I think the Court of Appeals put a lot of emphasis on, I don't really see a conflict. There's silence in 513C, and then there's in 504, there's a specific grant of authority to sue. So where is the conflict?
Okay, well, I don't think you can just say there's silence, because there was speaking before and now there's silence, and you have to look at those two together. But here is what I would interpret happened in 2001 when the legislature took away the power to sue. First of all, you have to look at what the purpose of this association is. Really, it has very little independent authority. It is subject to oversight by the insurance commissioner. Virtually everything it does is subject to approval by the insurance commissioner. The only thing that it does, and this was referenced in the prior argument, is it's ministerial in nature. It sends out notices, it calculates, it does the math, it calculates, and then it redistributes the funds that are collected to the private insurance companies who've suffered losses. The amount that you're compensated, the amount of the assessment, that's all set out in the statute. So really what this association does on its own is do the ministerial task of sending out and collecting and redistributing.
So what happens
So-
if,
Go ahead, sorry.
what happens if somebody has to collect, a member is not paying? Who sues?
The insurance commissioner, I would say, is who has the ultimate authority to get members to pay up. And that's pretty, I would say that's pretty clear under the statute, is that everything is subject, of substance, is subject to the approval of the insurance commissioner. So why did the legislature take away the power to sue? I think not because it was redundant, because they had no need to sue for anything.
In this statute, do you get the insurance commissioner's authority to sue from?
Because if you look through, and we've got it cited in our brief, but virtually everything that the Reinsurance Association has the authority to do, it says in parentheses, with the approval of the commissioner. So the commissioner really oversees whatever it is that the Reinsurance Association does.
Well, all right, so there's no express authority for the insurance commissioner to sue on behalf of the nonprofit, right? I mean, you're,
Well, I don't think the insurance commissioner needs express authority. The insurance commissioner has a lot of regulatory authority under the code over all insurance matters, which then kind of segues into the whole arbitration thing, because that ties into our argument that this really is a dispute between two arms of the executive
The
branch.
insurance commissioner approves everything almost any insurance company does in the state. So rates, they approve all those things. So that means that they sue on behalf of private insurance companies to them because they have approval?
You know, I think no. And I think if you look at the way the Reinsurance Association statute is structured versus the comprehensive statute, the Reinsurance Association has all those clauses in there that say subject to the approval of the insurance commissioner. The Comprehensive Association really acts as an insurance company because it writes policies. It's issuing policies, and that language about everything that it does with the approval of the commissioner is not in that statute.
Did the old statute where they said they could sue say with the approval of the insurance commissioner? That wasn't part of that part of the statute, was it? Be sued with the approval. It didn't say with the approval of the insurance commissioner.
That's right, and that's why I think that's very significant that the legislature had that language in there and then took it out. And
Let me change things here. Even if you're right, why did the court dismiss it rather than allow substitution of the parties as required by the rules of civil procedure?
Well, no, I guess I would not agree with that, because the issue was capacity to sue, and there is pretty clear case law that says capacity to sue is, in essence, a jurisdictional issue, and you determine capacity to sue at the time that the lawsuit is filed. So if the court didn't acquire jurisdiction because there was no capacity to sue in the first instance, you can't look back and correct the problem.
Why isn't this a real party and interest issue rather than a capacity to sue? Because the argument is that, and as the Court of Appeals found, the other entity would have a right to sue. I think that was implicit in their holding. And if the Court of Appeals was right, why wouldn't they, rather than dismiss it, send it back down under a real party of interest standard? Where is that?
Well, I think we disagree. The Court of Appeals did a fine job up until the last paragraph, and then I guess we would disagree with their conclusion that the other association has the right to sue. And what I would point out is that we still have two corporate entities that exist. We have the Reinsurance Association and the Comprehensive Association. They have separate corporate identities. All the Comprehensive Association is doing is managing the other corporation. As Justice Apple noted, it really, their board of directors kind of got merged with the other board of directors. So the Comprehensive Association, and it's clear in their statute, they administer the other entity, and they administer it solely within the confines of 513C. They don't have any independent authority.
But as I read what the legislature did, it did have that kind of problematic language about administer, but then they also made a change in 513C10, and they said that what I guess we call individual or reinsurance, whichever name we want to give it, shall exercise its powers through the board of directors established under Chapter 514E, which is comprehensive. So that seems to just make clear that all they were doing is merging the two boards of having one board of directors for both entities, right?
Well, the key is the language, and it says that the Reinsurance Association, so the corporate entity, shall exercise its powers. It doesn't say that you get the powers that the Comprehensive Association has over here. It says you exercise your own powers, and you have to look within 513C to determine what those powers are. And that's clear when the amendment got made and the board of directors was merged into the comprehensive. What the comprehensive statute got amended to say is that you're going to administer it subject to the terms and conditions of 513C. So I think
wasn't the legislature just trying to say the same thing in two different places, that there's one board of directors and it'll run both entities?
Well, but they did something substantive as well, which is took away the right to sue.
Let me just ask you a question. In point of fact, are there board meetings? Does the board have a meet for one entity and then they recess and then they or adjourn and then they meet for the second entity?
Well, I'm probably not the best person to ask that question to. Based on what I've seen from their agendas, they meet as one body, and then there's a separate agenda item for the Reinsurance Association business. So I believe that they do meet as one.
But your position is that neither comprehensive nor individual have a right to sue? Is that correct?
They do not have a right to sue these particular entities. I think I'm going to focus on just these, right?
So does it make sense that the Iowa legislature would impose an obligation to do these calculations and assessments and have amounts owing and yet not provide a collection mechanism?
Well, as I said, I think the collection mechanism is the inherent authority of the insurance commissioner to take action to enforce the terms of the statute.
But we've got in the Nonprofit Act a specific right to sue provision in 504-302-1, and we don't have anything in 513C or 514 that says they don't have a right to sue. If we read these together, aren't we left with a right to sue?
Well, I would say because this is a publicly created entity, that the scope is you only get the authority that the legislature gives you. And if the legislature doesn't give you the authority to sue, then I would say no, they don't have that authority.
Didn't they get it in when the legislature said in 2001 that individual is established as a nonprofit corporation? Doesn't that then carry with it the authority that the legislature gave to nonprofit
Well, then you have to look at what the nonprofit corporation says, which says general rule right to sue unless you're subject to regulation by another statute. And so you get back to 513. I would say what this court's responsibility is to look within the confines of 513C, and if there is no authority to take specific action, then this publicly created body doesn't have that authority.
But didn't the Nonprofit Act, it just says you have these powers unless they're limited by another statute under which you're regulated. And does in your view, silence is the limiting factor? Silence in light of the legislative history?
Well, silence in light of the legislative history, I don't think you can just ignore that. And secondly, because when the legislature creates a public body like this, it only gets those authorities that are specifically granted to it. And, you know, we did have the legislature saying originally you can sue. They took that away. So for some reason, you know, if they didn't need to give them the authority to sue because it was already in 504, why put that in the statute?
Is individual a board or a commission or a State Department or none of the above?
I think it is part of the executive branch of the state of Iowa. And
Doesn't the arbitration statute, isn't that expressly limited to boards, commissions, and departments? And I'm just curious what the university's position is. Which animal is it?
Well, I think those are kind of catch-all phrases, and really the intent is when you've got two executive branch agencies or entities that are fighting with each other, it's the governor's office basically that makes the decision. You know, I know this isn't in the record. If the court's inclined to take judicial notice, there's something called the roster of state officials. It's an official document published by LSA, and they identify as one of the under the executive branch agencies, the Comprehensive Association's Board of Directors as part of an executive branch agency.
If I may, Chief, what's your position on who should decide the arbitration issue if you lose on the first issue?
Well, I think it's up to the court to decide whether, in fact, the arbitration clause is called into question here.
And does that require any evidence? Is that a purely legal question based on the governing statutes?
I believe that the record is sufficient for the court to make that determination. I think you get there by reading the statute.
And this court should do it rather than remanding for the trial court to do it?
Yes, I think it's clear that any issue raised below is fair game on appeal. Thank you.
Thank you as well, Ms. Stahle. Mr. Lederer, you may present your rebuttal.
As I left, I noticed that I went over my time. I apologize. I'll keep this real short. The court has heard that the three universities, if they have to go this far, are going to deny that they are members. And I raise that because that tells you that their position is that an arbitration panel should decide that issue. And I respectfully disagree. I believe that it is for the judiciary to decide by interpreting the statute. With respect to 504, 301, and 302, I respectfully disagree with the reading of those statutes. 504-301 provides that a corporation engaging in an activity is subject to regulation under another statute, may incorporate only if that's not prohibited by the other statute. And then it says the corporation shall be subject to all limitations of the other statute. Well, there's no limitation in either 513C10 or 514A to the effect that individual may not sue, which means that individual has the power under 504, like any other nonprofit corporation, to sue. And again, it would just be a horrible result if any member could look at the bill they received from individual and say, which is exactly what happened here, because you and I and Iowa State were paying members for years. And it wasn't until the University of Iowa got what is, in all likelihood, a much larger bill, and they said, no, we're not going to do this anymore.
I guess the state would suggest the insurance commissioner will ride to the rescue.
First of all, the commissioner is a member of the board of directors for 514E and therefore 513C10. There's nothing in this record to the effect that the insurance commissioner objected or advised against or disagreed with the decision to sue. And there's nothing in either statute that says that the insurance commissioner shall bring a lawsuit to enforce. Instead, if you look at 513C10 and you look at the bottom of subsection 6, it says, it doesn't say anything about 514E's board. It doesn't say anything about 514E. It doesn't say anything about the insurance commissioner. It says the association shall have the express authority to require members to report on an annual basis each member's total health insurance premiums and payments for subscribers, contracts, and paid losses. A member is liable for its share of the assessment calculated in accordance with this section, regardless of whether it participates in the individual insurance market. So it says right in the statute that the member is liable. But there's absolutely no language there that says that if you refuse to pay, the insurance commissioner's coming after you. There's nothing in either statute that says that. That's a total creation. Thank you.
Thank you as well, Mr. Lederer. The case is then submitted to the court, and we'll now hear the arguments in the Young case.